National attention here for a graduate of an elite New England prep school in New Hampshire, accused of raping a 15-year-old freshman, allegedly as part of a contest that both sides say the evidence will prove their case. Keith Sullivan, criminal defense attorney, and Anna Yum, a former prosecutor, here to argue this. And good morning to both of you. Let's go ahead and lay out the case now. Anna, what is the prosecution's best evidence? Go.
You know what, Bill? I think the prosecution's best evidence is looking at the victim's behavior. Why would she make this up? And that's the question that jurors really want to know and resonates with the jury. Why would the victim make this up? Why would she call her mother in the middle of the night in tears claiming that he raped her? Why would she subject herself to such scrutiny and such speculation and possibly negative attention if this wasn't true? I think these are the facts that the prosecution is really going to have to focus in terms of swaying the jury and persuading them that the victim has no motive here.
So she'll be on the stand, right, Anna?
Right.
And it will come down to how credible she is in telling her story. You'd agree on that, right?
Absolutely. Okay. It's going to depend upon why is she here and what is she saying? Is she credible?
Now, Keith, to the defense, there are apparently text messages or emails between these two, or both.
Yes.
And as a defense attorney, what will those messages prove, do you believe?
Well, those text messages go to prove that there was no forced rape, and that's a big issue in this case. The prosecution is painting him out to be a monster, and as she pointed out, the prosecution on the clip, he doesn't look like a rapist. He sits there, he looks like Harry Potter. He sits there with his glasses on, this young, innocent kid. How could he possibly violently and maliciously rape this woman and plan it for months and months at a time, as the prosecution claims?
Okay, now that could be. I mean, he may look like an innocent guy, but come back to the evidence. Again,
sure.
What did the messages tell you as a defense attorney? How could you defend this?
Well, let's go to the scene. The evidence at the scene, there's no ripped clothing. There's no defensive marks on her. There's no marking. There's no bruising. The only indication is that some form of sex took place. Did it take place with him? Did it take place an hour earlier? Forensics will never give you that definitive answer. Then you look at the evidence after the fact, the text messaging, where she's joking and laughing with him about it. Look, many women have what's known as regret sex. They feel dirty afterwards. They feel guilty. She's a very young girl. She's only just maturing. Who knows? I'm not claiming that that's what happened here, but that's a possibility. And the idea that there's this...
Hang on one second, Anna, but that evidence will come into this trial. Now, Anna, if that is the case, then apparently they were text messaging about protection used during the alleged act. Now, as a prosecutor, is that a problem for them?
That is going to be a problem, Bill. I think the prosecution is going to face a hurdle in explaining why she was allegedly flirting with him after the fact and exchanging these text messages. But let's keep in mind her age. She's also only 15 years old at the time. She lacked sexual experience. This was her first time engaging in sexual activity with this guy. So I think that the prosecution is going to have to ask the jury to take that into consideration. This is not a woman who has a lot of sexual experience. This is a woman who may have been
but
confused,
as a prosecutor,
a young girl.
You would have to prove that she did not consent to this, correct?
That's correct. As a prosecutor, they'd have to prove that she did not consent. Now, if he's looking at statutory rape, the legal age in New Hampshire is 16 years old. So if she's 15, she's not capable of consenting. But in terms of any kind of forced sexual assault, in terms of rape, yes, the prosecutor would have that burden, and that's going to be tough.
To both of you, Anna, is this a hard case to prove or not?
I think it is. I think it's going to be a difficult case to prove, just because I think her conduct after the fact is something that she's going to be subjected to in terms of tough cross-examination. Wow. If she really didn't want this to happen, why is she engaging in these text messages and emails?
Keith, what do you think happens here?
I agree. I think it's a tough case to prove. My own opinion doesn't really matter, but I think there was consensual sex that evening. He'd be guilty of statutory rape. However, New Hampshire has what's known as a Romeo and Juliet law, which takes a statutory rape from a felony down to a misdemeanor if it's a consensual act. And unfortunately, the defense did not go with that theory. They went with there was no rape.
These are serious charges: 10-count indictment, 4 felonies, 6 misdemeanors, and on it goes. Aggravated felonious sexual assaults. 3 women on the jury, 11 men in New Hampshire. Thank you, Anna, and thank you, Keith, as well, for analyzing this.
Thanks, Bill.